Now we consider issues relating to real property use. Land use is the topic of this video and the following one in this series. First, we're going to consider easements and covenants. We begin with easements. An easement is a non-possessory right that one holds in the land of someone else. That's what an easement is, the right to use somebody else's land. You can't have an easement across land you own. We can't have an easement where there is only one landowner. We've got to have two landowners. And we'll see that there are three types of easements: express, implied, and prescriptive. And this is straightforward material, and compared to a lot of the other stuff on the outline, it's really easy. So we consider the creation of an express easement. An express easement has got to be made in writing, and it's got to be signed by the grantor. An easement by grant must be recorded in order to bind bona fide purchasers of the benefited land. That's basically it. An express easement has to be done in writing. Here we can consider issues relating to deeds, and we'll consider deed issues somewhere down the road on this series of substantive videos. But the bottom line here is express easements are easy. All you've got to have is a writing, and it has to be a satisfactory writing. No problem. But where we get to implied easements, it becomes a little bit more complicated. Fortunately, this material is tested very commonly over and over again in the very same way. An easement by necessity or an implied easement can only happen at the time that a communally owned parcel is divided up. We can't have an easement by implication or necessity unless we go way back in time to the point at which a parcel is subdivided, leaving one parcel, or maybe more parcels, landlocked. An easement by necessity will end at the time that the necessity ends. But an express easement, in contrast, continues beyond the need for it. So we see that an express easement is a more solid easement, a more concrete interest in land than an implied easement or an easement by necessity. An easement by necessity goes away whenever the necessity is over with, whereas an express easement is more solid, it goes on much longer. Also, realize that an easement for light and air cannot arise out of necessity or implication. An easement for light or air has got to be express, it can't be implied. And that leaves us with only one more type of easement to consider: a prescriptive easement. And here again, I've done the same thing I did back in adverse possession. I have listed the elements of a prescriptive easement. So you see that it's got to be open and notorious, adverse, continuous and uninterrupted for the statutory period. This is exactly the same set of elements as we saw in adverse possession. So a prescriptive easement could easily be called an easement by adverse possession. And remember, as we considered the issues of adverse possession earlier, I rehearsed the same elements, but I reminded you that to really think about the material, you don't need to get bogged down in those elements. Realize that what is really going on here is the claimant has got to show a mental element, a physical element, and a time element. And with regard to the physical element, both in adverse possession and here in a prescriptive easement, we focus on the use of the land that would be common in the area. So if we're dealing with an area, a parcel of land that can only be accessed 1 month out of the year, 1 month occupation is all we're going to require in order to establish a prescriptive easement. Obviously, 1 month a year for whichever number of years. So a prescriptive easement or adverse possession of an entire parcel is measured in this fashion. Now, the most commonly tested issue with regard to prescriptive easements is this. It arises out of the fact situation where the person claiming the easement first relies on an express easement. Typically, the claimant fails to record this easement, and so it doesn't put third parties on notice as to the existence of the easement via the title check. However, we've got a party that actually is occupying the land, actually using the easement. Here's the most commonly tested fact seen. Suppose the easement is granted in a deed for 40 feet, but in reality, the claimant only uses 25 feet. Well, if the claim to that easement by deed fails, the express easement fails, and the plaintiff has to rely on adverse occupation in order to show a prescriptive easement, under those facts, the plaintiff, if successful, only will be able to claim an interest in the 25 feet of the express easement that actually was used. And that's the way to figure out the interests with regard to a prescriptive easement. Typically, the express easement has failed. The plaintiff has to fall back on the part of the easement that was actually used. Now, once established, once a prescriptive easement has been shown, after the statutory period with the right hostile mental, affect, etc., once established, a prescriptive easement need not be used continually in the future. Once it's been established, it exists, and failure to use it doesn't ruin it, doesn't invalidate it. Also, with regard to the use of an easement, to the extent that the owner of the burdened parcel consents and gives permission to the plaintiff to use that easement, that's enough to destroy the mental aspect. A person who is using an easement with permission is not using that easement with the correct type of hostility. The person using the easement may not like the person that has given them permission, but the act of giving permission invalidates the mental element of adverse possession, and a prescriptive easement cannot follow from a permissive entry. Also, realize that a person claiming a prescriptive easement via essentially adverse possession need not be the exclusive user of that easement. Suppose we've got a situation where a number of different parties are using an easement across Blackacre. And let's suppose that each one of them has done so with the right mental attitude for the right period of time. Well, each of those parties may end up with a valid claim to a prescriptive easement. The bottom line here is, to claim a prescriptive easement, the claimant need not be the exclusive user of that easement. All right, that deals with the creation and use of the various types of easements: express, implied, and prescriptive. How do we terminate an easement? How do easements end? Well, the most common way for an easement to end would be based on the terms of the original grant. If we've got an easement which is foreseen by the parties to have a shelf life, at the time the shelf life is over, the parties will mutually terminate it by agreement, essentially, by the original grant. The next most common way for an easement to disappear is through merger, when the benefited and burdened parcels are both owned by the same individual. There's no longer a possibility for an easement, because you can't have an easement across property you own. You can only have an easement across some other parcel of land. Once you own them both, there's no longer the need for an easement. Also, it's possible for a party to be released from an easement. It's possible for the benefited land ultimately to just say enough and unilaterally release the burdened party from that burden. Next, a most commonly tested idea about the termination of easements is abandonment. Does abandoning an easement terminate that easement? Answer: no. No, it doesn't. We've got to have the intent to abandon, the intent to avoid an easement, in order for that easement to go away by abandonment. Mere abandonment is not enough. The person doing the abandoning has got to intend to give up that easement also. And finally, estoppel can be used both to deny the existence, both to prevent the denial of the existence of an easement, and also to prevent the denial of its termination. So this issue of estoppel, principally arising out of the law of contracts, has broader implications in the other subjects that deal with civil litigation. So you can see estoppel arguments here in real property. You can see them sometimes in torts. You can see them in wills and trusts, even in litigation arising out of business organizations. The idea of estoppel is essentially one that arises out of equity, and it's one that deals with the relationship between the parties. So, for examination purposes, and also in real-life legal practice, focusing on the relationships between the parties at issue is very important. That leads us to consider covenants. Covenants are the next big cluster of issues dealing with land use. And a covenant is an agreement relating to land. I think it's important to realize that the law of covenants really arises out of the law of contract law as relates to real property. So, in order to have a covenant that will run with the land, the original parties have to satisfy contract requirements. And so, since we're dealing with an interest in land, a writing is required. Now, when we get to contract law, which, if you're doing these seminars in the order I present them, comes after real property, you'll see that the structure of a contracts analysis is quite important. And so let me preview it for you here. A contract will have a series of issues relating to contract formation, defenses to formation, performance and breach, defenses to performance and breach, remedies, defenses to remedies. That's the structure of a contracts analysis, and sometimes it's necessary to use that full structure to consider a contract that arises out of real property. So I will leave it at that for the time being. We'll go over these issues in hypotheticals, both here in real property and in the law of contracts. But to conclude, let's just go through the elements that are required to show whether a benefit or a burden will run with the land. First, we consider the requirements for a burden to run, and then we consider the more streamlined and simpler requirements for a benefit to run. As we consider the requirements for the burden of a real estate covenant to run with the land, we see that the claimant has got to show intent, notice, horizontal and vertical privity, and touch and concern. And we'll go into each of those elements in a little bit more depth when we're dealing with hypotheticals. The difference between the requirements for the burden to run and the requirements for the benefit to run are, it takes a lot less for the benefit to run. All we need are intent, vertical privity, and touch and concern. And that wraps up the first part of our consideration of land use. Remember that all of the issues from land use, taken as a whole, only add up to about 6 or 7 MBE questions. But this material is commonly tested on the essays as well.